Okay, welcome to the People's Law School. I am Larry Springberg, your host tonight, and for the next 3 Tuesday nights. We have 4 incredible evenings of interesting and informative presentations. By participating in this program, you are part of 25 years of People's Law School history. We will provide diplomas at the final session, and you will have in your hands a useful souvenir reference guide, the People's Law School Handbook. Please note that we are videotaping the school, so people who can't be here due to the distance or other commitments can also participate. Because we are on a schedule and the presenters have quite a challenge to cover their material in a short time frame, we ask that you write your questions on the index cards provided to you and hold them up for us to collect. If you don't happen to have any questions this evening, please hang on to your index cards for one of the following sessions. We will then ask your questions at the end of the presentation, and we'll do our best to get to them all. Please allow me now to introduce our first speakers of the evening. Senator Mo Denis is a graduate of Rancho High School in Las Vegas. He received his Bachelor of Arts degree from Brigham Young University. He was elected to the Nevada Assembly in 2004, served in the Assembly until 2009, was elected to the Nevada Senate in 2010, and was the Senate Assistant Majority Whip in the 2011 session. In total, he has served in 6 special and 4 regular sessions in the legislature. Our other speaker is Assemblyman Marcus Conklin. He first ran for the Nevada Assembly in 2002 and is now serving his 5th term. In 2009, he served as chair of the Assembly Commerce and Labor Committee, and since the 2011 legislative session, Marcus has served as the majority floor leader of the State Assembly. Marcus has taken on the big banks and special interests to protect vulnerable homeowners in Nevada. In the 2011 legislative session, Marcus authored legislation that changed Nevada foreclosure law by adding more strict requirements before a foreclosure can proceed. Marcus took decisive action to shut down fraudulent foreclosure programs. Please join me now in welcoming Senator Denis and Assemblyman Conklin, who will speak about the citizen's role in the legislative process.
Go ahead.
Well, welcome. We're excited to be here with you to be able to speak about the process of the legislature. I was just speaking just a few minutes ago with someone who's out one of the candidates that's out knocking on doors, and it's amazing, but understandable that many people don't really understand the legislative process. So we're gonna talk a little bit about that process, and hopefully, if you have any questions, you'll hold on to those and ask those at the end.
Just by also welcome, and just by way of introduction, this is my colleague Senator Mo Denis, and I'm Assemblyman Marcus Conklin, and we hope you get enough out of this to make your next foray into the legislative arena an exciting and fruitful opportunity. So welcome. So let me start with just a brief overview of the Nevada legislature. Nevada is one of only 4 states in the union whose legislature meets only once every other year, known as biennial sessions. The Nevada Constitution makes Carson City its capital, in spite of the fact that nearly a little more than 2/3, almost 3/4 of our entire population lives down in Clark County. Senators serve 4-year terms, so Mo is in the middle of his first 4-year term in the Senate. Those terms are staggered, which means not all the senators are up each election cycle, which occurs every 2 years. And assembly members serve 2-year terms, so each election cycle, the entire body is up for re-election. Also, I'm sure you're well aware that all legislators, like many other office holders in the state of Nevada, are term limited to no more than 12 years. Then technical language is in each office. So you could serve as an assembly member in 2 different districts, but that still counts as only one office, and you can only serve as an assembly member for a total of 12 years. Doesn't have to be consecutive, but it's still capped at 12, and the same for the Senate.
So let's talk a little bit about the time frame of the legislature. The Constitution in 1998 was changed to restrict our sessions to 120 days. You can imagine, when you meet every other year, 120 days is not a lot of time. It seems like a lot when you first start, but by the time you get to the end, you wish you had a little more. We have another year, well, actually, till February 4th, we'll begin again. It always starts in the first Monday in February and goes to the first Monday in June. Keep going. So during the interim, we have interim committees that we serve on. In fact, we just came from a meeting just that we spent all day talking about the interim finance, and we have that. We've been on that actually for several years now together. But we have other committees that meet: education, healthcare. We have one committee that's studying how other legislatures meet, especially we talked about the annual sessions. State of Oregon just recently switched from a biennial to an annual session, and so we're studying to see the kind of things that we can do to improve the legislature.
So one of the more exciting things, well, I suppose it's exciting, it depends on your point of view, that we've recently done is the last census was completed in 2010. And as a result, the legislature is obligated to redraw the legislative boundaries for all of its elected offices. And this is known as redistricting. Despite population concern, population growth, and budget concerns, generally we have left our what's known as apportioned number of seats alone. Apportionment is different from redistricting in the sense that we decide the number of seats that will actually be in each house of the legislature. We've left that alone. So as population grows, each legislator will represent more and more people. We could alter that. We've just chosen not to, largely because of budget concerns. One of the other interesting things to note out of this last census cycle is that Nevada's Hispanic community has nearly doubled over the last 10 years, growing to right at 25% of the state's population, particularly concentrated in southern Nevada.
An interesting side note to that is that when I got elected, I was the only Hispanic in the assembly, and this last session we actually went from 2 to 8. So that's kind of starting to mirror a little bit what the community is as far as our representation. So what happened in redistricting? So it stayed at 63 members, as was just mentioned. There's 42 in the Assembly and 21 in the Senate. Also, 1 Senate seat and 3 Assembly seats shifted to Clark County. One thing that's different this time also is that we have nested this time, so that we have 2 Assembly seats make up a Senate seat. So now, if you live in an area before, in my Assembly seat, for example, I had Assembly seats all around me, but I had 2 or 3 senators that also had portions of my district. Now, in the Senate, I have 2 who happen to be Assemblywomen that are serving. So that's kind of an interesting, and it's actually better for I think the community to kind of understand what district they're in now, because it's 2 to 1. We have 15 Senate districts and 29 Assembly districts that are wholly within Clark County now. As was mentioned, because of the shift in population, several of the seats have come down to southern Nevada.
And just as a side note, relative to or regarding the 63 members that we have in the legislature, the Constitution actually caps the number of members in the Nevada legislature to 75. And it provides that the legislature determines the exact number based on the following criteria: that you can have no more than half as many senators as you have Assembly people, and no less than a third. So at 75 seats, you could have 50 Assembly people and 25 senators, or you could have up to 59 Assembly people and 56 and 19, I had to get that right, 56 and 19 senators. And so the legislature, through apportionment, can alter those numbers as it sees fit. If there are pockets of folks who maybe don't get the appropriate representation, they can increase their numbers to be able to draw the boundaries better, to create better representation in the legislature.
So in the legislative offices that are up this time, as was mentioned earlier, not all of the Senate seats are up every time, so they alternate. We actually have 11 of the 21 Senate seats that are up for election during this cycle. And also, as was mentioned earlier, all 42 members of the Assembly, all of the members are up for election. We have a primary election that's coming up with early voting starting 2 weeks before that, but the primary election is on June the 12th. With the general election being November the 6th.
This is a common trait that you see amongst many of the state houses around the country, with the exception of Nebraska, which has a unicameral legislature. All the other legislatures in the union are bicameral, much like Congress is. And they're built around the premise that the Assembly or lower house will be up for election on a frequent basis, and in the eyes of the framer, that no vote will ever be too far away from the next election, so people will remember what your actions are, as opposed to the Senate, who would be smaller in nature but serve longer terms and be a little bit insulated from the people, so that they could make decisions without political punishment, if you will. And that's also reflected in our House. As a matter of fact, it's a condition to become a state in many cases, in all cases, under the United States Constitution.
And on the primary election, that's something that since we've been in has actually changed. It used to be in September. We moved it to August, and then we've moved it to June. So it's actually been, over the last 10 years, you've seen it change a few times.
Just by way of giving you an opportunity to look when you have time, there are a couple places we might recommend where you can get information regarding this election and any future election. Of course, the Secretary of State, as you may know, is the statewide constitutional officer who governs elections in the state of Nevada. And his website is www.nvsos.gov. And you can find on the front page, the second bar over, talks about the election department and all the information you'd ever want to know about running for office, voter statistics, past races, races that will be up this time. A whole plethora of information you can find on that website. You can also go to the Legislative Council Bureau's website at www.leg.state.nv.us and look under the Vote Nevada page. Now, this is the legislative website. It's the website that represents our body, and it's another tool that you can use to get educated about what's taking place in your community and your state in the upcoming election cycle.
So, the importance of the election is, if you're going to vote, it's good to know who your legislators are. And that's really an important point here, that if you get to know your legislator and there's something that's real important to you and your legislature knows you, there's that rapport that can be built there, and that gives you an opportunity to work with that legislator. Consider various things you could do is to consider campaigning for a candidate of your choice in the Senate or the Assembly. Get familiar with the issues and attend campaign events to learn candidates' positions, and contact candidates in your district and let them know about your concerns and ideas. And many of the legislators are fairly easy, well, in most cases, fairly easy to get a hold of. Even though we're busy and we still work regular jobs, we want to hear from our constituents. So it is important to get to know them and call them and talk to them.
So we alluded to this earlier. The current time frame in legislative speak is the interim period. We are between legislative sessions. The last one concluded in early June of last year. The next one will begin in February of next year. And this period in between is kind of a lull in the cycle where your legislators, who are commonly referred to as citizen legislators, have an opportunity to go home, work in their community. Most of them have full-time jobs. Have a family to support, a career to tend to. But during this period, some work does still get done. We have interim study committees that cover a wide range of topics. Some of them are standing committees. Some of them are nuanced studies that happen only once in a while. Some of our standing committees include education, health, public lands, seniors, veterans. But you'll also find for example, this cycle we have 2 education finance studies, one on K through 12, another on higher ed. And those are studies that don't happen on a regular basis. They're happening this particular interim with the hopes that next session we can tackle some broader issues related to education finance. They got these backwards. If you're interested in the list of the interim studies that are taking place Currently, I would encourage you to go to the legislature's website, which, as I mentioned earlier, is www.leg.state.nv.us. And you can find there's a bar up on the top left-hand side that says legislative sessions. You can click on that and pick out interim sessions, pick out the current year, and find all the information, all the legislative events that are going on currently in this interim cycle. Interims are very useful in the sense that they pave the way for the issues that will come up in the next legislative cycle. And unlike during a legislative session where we have many hearings in Carson City, this allows legislators like Mo and myself, who live down here in Carson City, to hold meetings down here where ordinary working people will have an opportunity to come and participate, and we can take that feedback back to Carson City when we go. So it is kind of a unique opportunity.
And even if you can't make it down to the legislative building, which most of our meetings are down at the Sawyer building on the corner of Las Vegas Boulevard and Washington, they're also video conference. So you can actually go onto our website, click, and actually monitor one of the meetings. So how do you get involved in interim committees? You could sign up and you will get the agenda. So if education is your thing, then every time a new meeting gets posted, or you will get an agenda, so you'll know what's coming up. And then the minutes are also available. They lag a little bit because they have to take them afterwards, but eventually they'll put them up. And there's also historical on minutes, so you could go back and look at previous meetings. Interim committee is also a great way to get to know the issues and the people that are involved. Not only legislators, but there are those who are advocates or others, or lobbyists, that have an interest in particular parts of whatever it is the topic, and you can get to know some of those individuals, and I think that's an important thing, to know those that have an interest and to know both sides of the issues. And unlike the session, they meet over, as I said, at Las Vegas Boulevard and Grant Sawyer, which is 555 East Washington.
One of the things that comes out of most interim committees is an opportunity for the bodies to generate some bill draft requests. A bill draft request is, as we call them, BDRs, is basically the infancy stage to a piece of legislation. It's our opportunity to make a request of an issue or subject matter and to put, as legislators or committees, depending on who's putting in the request, to let legal know what our intent is next session by way of a bill. Not only do committees get bill draft requests, as interim committees, the average interim committee gets 5, but each legislator also gets a limited number of bill draft requests. And I think now the number's around 13 for every assembly person and 26, if I'm not mistaken, for every senator. That is something that's usually done by statute or rule. The body decides for itself how many bill draft requests each member is going to get. Interestingly enough, unlike Congress, where the only people who can introduce bills are members, in the Nevada legislature, the legislature itself has granted the authority to some agencies and other elected offices to be able to bring their own issues to the legislature as well. So the governor gets, I think the last time I counted, about 80 bill draft requests in a cycle. The Secretary of State gets a few bill draft requests. The Attorney General gets some. The counties will get a few. Some cities will get a few. That way, as their issues come up that need to be addressed in statute, they too can participate in the legislative process. After a request is made, the bill is drafted, and its very first introduction to the process is when it gets introduced on the floor of either house, the Assembly or the Senate. And once it is introduced and read into the record, it is assigned a number and then referred to a committee for a hearing. And committees are really where all the work gets done on these things.
So session committees are organized by topic, such as commerce and labor, education, government affairs, health, judiciary, transportation. And I believe this is going to talk on occasion, and also you will get special committees that are also created for the session. After referral, the committees may hold a hearing to take testimony and hear proposed amendments. I think the key word there, and in the legislature, there's always key words. May hold a hearing, so sometimes you may not get to hear that because the chairmans determine whether they bring those forward. They may recommend a bill to be passed, either do pass or do pass as amended. And you see that a lot where the bill will come forward and maybe there's some changes that need to be made, and so it'll get amended and it get passed and amended and then sent back. They also may kill a bill by not voting it out. Sometimes you will see that where the chairman may just decide not to take a vote on it. Or if they do take a vote and it doesn't make it, then it just doesn't get sent back.
So we use this as a teaching tool when new folks come to our body as a way to kind of illustrate a combination of things, both the frustration from a legislative perspective, but I'm sure as citizens it's also frustrating to see some of the outcomes. But I think it explains a lot. Up in the top left hand, you can see that some legislator had the perfect bill introduction, right? A beautiful swing or ladder, I'm not exactly sure what it is, a three-person swing, we'll call it. And they send that to committee, and in the infinite wisdom of the committee, they decided that 3 seats were too many, that it really should have only one, that safety requires that only one person should ride this swing, and actually sounds like a pretty good idea. As I said, this is where most of the work gets done on these things. And so they report it, the committee reports it out, and they send it down to the floor or the House. On the floor, somebody, a single member, gets a hold of it and decides to amend it again. And maybe it doesn't accomplish the same purpose it was originally intended for. As you can imagine, in this case, nobody will be swinging on it. And the Senate sees this as a problem when you send the bill over to them, so they readjust it again, only this time it could be swung on, only there's a hazard, isn't there? There's a tree in the way. And we're not sure finally, because then it comes back to what's known as a conference committee, if that's going to be good enough. So we put these supports in the tree and cut out a space so now it can be swung on. Need I go any further? You can see what happens to this, and in the end, sometimes what it looks like is the public, which probably wanted the bill in the first place, had something completely opposite in mind. When they talk to some legislator. So this is what the process is like. I think this is a little bit of an over-exaggeration, but certainly it's what it can feel like from time to time.
Well, and one thing about this is that it has it going from the House to the Senate, but it actually would have gone back a couple trees where we had a couple more chances to work at this. And so, yeah, definitely it's an interesting process.
Yeah, I love what the budget allowed was nothing at all.
Yeah.
That's usually the death of most bills.
Yeah. So how does the bill then become law? So we've mentioned the word floor. The floor refers to the Assembly or Senate, and that's really where we meet as a whole body. And we have the Senate is on one side of the legislative building and the Assembly is on the other. And we have our chambers, and that's what we consider the floor. If a bill gets voted out of committee, then it goes back to the floor for possible action in the House. If the first House then votes to pass the bill, then they send it to the other House, and it repeats that same process. So the process of getting assigned, it goes to the other House where it gets assigned to a committee. The committee will then meet and they amend it or whatever, send it back to the floor, and then it gets sent back to the original House.
This is one of the subtle differences between Nevada and Congress. Is in Congress you have 2 parallel tracks. You'd introduce similar bills, one in each house. They'd move through the process, and then when you find out at the end that they are different, and 99% of the time they are different, then they go to a conference committee, a committee with members from both houses, to hammer out the details and send the same bill back. In the Nevada legislature, you start only with one bill, and it starts in a house of origin, and that same bill moves along the entire process. So it could get amended all along the way, but you're still only working from one bill, from one piece of legislation. So let's talk for a minute about the governor's role. As is common throughout the United States, the governor can sign a bill or let a bill become law without a signature. Depending on when the bill is delivered, he or she can decide to veto a bill, and depending again on when it's delivered, he may have up to 10 days to do so. The vetoed bills go back to the legislature either in the same session in which they were passed, if the legislature is still in session, or it can go back to the next legislative session if the legislature is out of session when it gets vetoed. All bills require a 2/3 majority vote in both houses in order to override a gubernatorial veto. Can I take this slide?
Yeah.
One of the subtleties about Nevada law, which is unique, is the fact that we have an interesting population dynamic. As you can see from this slide, we have only one county with 700,000 or more people in it. That would be Clark County, which has roughly just short of 2 million folks. They're just short of 3 million in the state. So a substantial amount of our population lives down here. And when you see over on the left-hand side this population range, sometimes in statute you will find laws that have this population range in them. And I'll give you a classic example. The laws in Clark County relative to tractors, farm equipment on the streets might need to be different than the laws relative to, let's say, Eureka County and farm equipment on the streets. Why? Because generally our streets in Clark County are quite urban, and to drive a tractor through them could create a problem. As opposed to Eureka County, which has only 1,987 people in it, and the streets are not as populated as they would be here. So sometimes in our statute you see something that says, in counties whose population is 700,000 or more, the following law applies. And so it's something that's quite unique to us because of the very nature of our urban versus rural populations.
So in talking about legislative goals, if you're looking at doing something, let's say there's a particular issue that's important to you, you want to have some goals and a process on how you want that to happen. Keep in mind that this legislative process that we've talked about, you could start a bill this time and it may, some of these take maybe up to 10 years. We only meet every other year and sometimes you get a little piece of it. Sometimes you have to keep bringing it back and modifying to get something through. But so first of all, you look at your ideas and then do you want to protect existing laws from unwanted changes, from amendments? Or do you just want to stay informed? Those are all important things, and there's ways that you can do that.
Once you've defined what you want or what your legislative goals are, then it's time to start participating. If you have an idea for a bill, the most appropriate place to go is to your legislator. As I said before, every legislator has a certain number of bill draft requests, and they do work for you. Be prepared to explain the problem and the facts around the problem and have a proposed solution. That's the most expeditious way to get support for an idea that you have, at least relative to a legislator. Let the legislator know who might also be supporting the bill and who might be opposing it, because in the legislative arena, all of those are important. There generally isn't a piece of legislation that comes in or out of our process without some opposition. We know there's people in support of it because that's how it got there in the first place. But there's always opposition, and considering the facts around the opposition and how they might approach the bill is helpful in terms of either keeping a bill alive or finding a compromise that moves a bill forward.
And one thing that's important in that process too is never use the word simple. When you're trying to explain that your problem is real simple and it has a simple solution. As legislators, we know that simple usually means there's going to be a lot of complications with it.
The simple changes are things like changing an and to an or, right? Or shall to must. It's the little things that become the hardest to tackle in the legislature. In terms of testifying before a committee, once your bill draft is drafted and introduced, it is sent to a committee. You'll want to come and support that, especially if it was something you brought forward in the first place. Each time you come into a committee room, you'll want to sign in, and because time is limited, you want to make sure that you have prepared remarks. Because our time is limited, 120 days, it's critical and probably most effective for each person who comes to testify to be brief, to be to the point in order to keep the bill moving. Do not, if you can help it, repeat the testimony of other speakers. Legislators, again, have a lot of work to do in 120 days. It's a lot of time to resolve many things, or at least attempt to resolve many things. And if 20 people line up to give the exact same testimony, some legislators will divert their attention to other things, when really what needs to happen is have a clear and concise testimony. And if that is all that needs to be heard, then step back and allow the bill to be moved. A lot of chairmen will actually, instead of allowing multiple testimony that appears to be identical, will ask those in the audience who agree with testimony that's previously given to stand up, so the committee can see the strength of support that's shown out for a bill, without actually having each person come up and say, I agree with that guy, me too.
So don't forget that when you are sharing your testimony, if you got a personal experience, share those, because those really do make a difference. I think we're going to speed up a little bit here so we can get to the questions, but you know, you can read through these. If you have handouts, make sure you bring enough. So, you know, just think it through, because you want everyone to be able to know what your issue is.
Be informed, know the pertinent facts about your bill, understand the opposition, be prepared to address their arguments, enlist the support of groups and lobbyists that share your point of view. And sometimes that's the hardest thing to do, but it's also the most effective. Generally, there's not just one person advocating a bill. There are multiple groups. All you'll have to do is reach out to them and let them know that it's coming, and they'll be more than happy to help you.
So contact your legislators. Personal contact is important. Find those that have an interest. Some legislators, for example, education is a really big thing for me, and I have a lot of interest in that, but I have other things that I'm interested in. So find someone that can do that. And then remember that we do have over 1,000 bills that we have to deal with in a session and read and ponder, and so be brief.
Some tips or other rules of the road. Are we getting the, okay. I'm going to stop right there.
All right. So everyone, I'd like to thank Assemblyman Marcus Conklin and Senator Mo Denis for their presentation this evening. And we do have 2 certificates of appreciation. It's my understanding that there have been, oh wait, there is going to be a question. Okay. First question, who makes up a committee? And either the Senate or the Assemblyman, how are the committees formed, I think is what the question is.
In the Senate, it would be the majority leader would determine, in consultation with the minority leader, who makes up the sessions, and all that depends on what the difference is in the majority. So the more you have in a majority, the more people you're going to get on a committee.
And the Assembly works largely the same way. The Speaker makes those appointments, who's the presiding officer over the Assembly, and usually in consultation with the minority leader, at least for the assignments that the minority would like their members to take. As just a caveat to that, lots of things are taken into consideration, both if you live in a rural area, natural resources, mining, and agriculture is a committee you might like to serve on, because those are the issues that are important to your constituents and your community. If you live in Clark County, you may be more inclined to be on, for example, Ways and Means, which is the committee that determines where money will be distributed. And all of that goes into the mix of trying to decide who will go where, along with their individual experiences. Some people are economists, some people are farmers, some people are teachers, and their area of they offer an area of expertise that the entire body can take advantage of if we place them in the right spots to be successful. So we consider all of that.
And then our second question, are earmarks allowed in the Nevada Legislature? And I think this is they're referring to the federal practice of adding on certain requests to bills that sometimes have nothing to do with the bill.
Yeah, we generally have, there's a rule in the Nevada Legislature that amendments to a bill have to be germane to the subject of the bill. So in the classic sense of what takes place in Congress versus what takes place in the Nevada legislature, I would say no. That doesn't mean that from time to time there isn't an amendment that tests the limits of what is germane. But it's kind of one of those things that the body protects itself from inappropriate amendments, because once you start allowing them, then everybody starts piling on. So, and because we're time limited to our 120 days, when those amendments really start flowing late in session, adding an additional amendment may kill the whole bill.
And with regards to earmarks, so can the amendments take the form of requesting money for a specific project in a legislator's district?
I've not seen one. I've not seen one in the time that I've been there. When times were good and you had revenue beyond what the budget required, the legislature would certainly consider projects. But I mean, our districts are so close, and the projects are, no one legislator represents the entire district. So if I had a special request to do, for example, several years back, I had a request to audit the Clark County School District, which required, I want to say it was close to $500,000 to get the audit done. I mean, certainly that would benefit my constituents, but it would benefit all of the folks who in Clark County, because the district itself, you see, so it's really hard with the tiny districts that we have to have earmarks that are specifically targeted to one district. They permeate all the districts usually.
It would tend to be more probably in the whole county versus, and you'll see, but legislators may have specific projects that they would like to see, and they could do that. But I think the other key there was if we had money, and we haven't had that. We haven't had that problem over the last few years.
We'd like to have that luxury.
Yeah.
All right, thank you again. All right. And on behalf of the People's Law School, we'd like to present each of you with these certificates of appreciation. Senator Denis.
Thank you.
And Assemblyman Conklin.
Thank you.
Thank you very much. Thank you for the presentation. Thank you.
Go sit.
Okay, we're going to move on to our next presenters, and after this presentation, we will take a 5-6 minute break for whatever needs you might have. Our next presenters are Beverly Salhanick and Kent Ivey. Beverly is a sole practitioner in Las Vegas, concentrating in the areas of general civil litigation, commercial, bankruptcy, intellectual property, collections, and probate. She received her bachelor's degree in journalism from Mount Holyoke College and her Juris Doctorate at Vanderbilt University School of Law. Beverly is admitted to the United States Supreme Court, the State Bar of Nevada, and the State Bar of California. She is the Nevada liaison to the American Association for Justice's Women's Caucus. She chairs the Nevada Justice Association's Women's Roundtable and is a member of the Nevada Justice Association's Nevada Legislature Bill Review Committee. Kent Ivey has been a respected bankruptcy attorney and small businessman for over 20 years. After graduating from high school in Rialto, California, Kent attended UCLA on an NROTC Marine Option Scholarship and received his airborne wings at Fort Benning, Georgia. Kent went on to Pepperdine University School of Law, where he was selected as a member of the Moot Court Honor Board in his final year. Kent is committed to giving back to his community and is involved in numerous volunteer activities, including providing pro bono legal services through the Nevada Legal Aid Center of Southern Nevada. Please welcome Beverly and Kent on their presentation on personal bankruptcy.
Good evening, ladies and gentlemen. I'm Kent Ivey, and along with my co-presenter, Beverly, we wish to thank you for this opportunity to speak to you tonight. Now, we'll be talking about bankruptcy basics. And when we talk about that, we have a subtitle here, what you need to know before you see an attorney and what you really do need an attorney in this area. It's gotten so complex that back in 2005, Congress changed the laws in reference to bankruptcy. At the pushing of the credit industry, many things were changed. It became much harder for them to, or individuals to file Chapter 7s. And I'll get into that in just a moment as to what a 7 is as opposed to a 13. But the whole idea was they were thinking everyone was going out, running up their credit cards, and then running into bankruptcy court, and that wasn't the case. Since I've been practicing law, those types of cases are few and far between, and it still isn't the case. There are 4 basic reasons most people file bankruptcy today. One of those is being laid off from your job. Second is medical issues, and sometimes that dovetails into the first because you get into a car accident, then you can't work, so you don't get a paycheck. So you have problems there. The third issue is divorce, and the fourth has to do with the real estate mess that has occurred in the last, well, you've probably all seen it in one way or another. So those are the 4 main reasons. Now, what is bankruptcy? It is a court-supervised process by which you either liquidate your debts or you're able to work out a payment plan, and oftentimes you're paying cents on the dollar, anywhere from 10 to 30, maybe 50 cents on the dollar. So you're looking at that, and then, so we have this Chapter 7 or Chapter 13 situation that you've most heard about. We have 4 types of bankruptcies that actually apply to individuals. There's the 7 and 13, but there's also 11 and 12. Now you go, 12? I haven't heard that one much. If you lived in Central California, you probably would. It has to do with family farmers, and most people I say, hey, I didn't see you come into the pit with a pitchfork, so I'm not really going to talk too much about that. So then there's 11, and everyone thinks, oh, 11, that has to do with bankruptcies. Well, yes and no. There are individual Chapter 11s, and we've seen more and more of those today because of the amount of real estate debt people have. Because there are certain requirements in 13, and that's the payment plan type of bankruptcy, that if you go over these limits, you then have to file a Chapter 11. And those limits, those 2 basic limits are unsecured debts of over approximately $365,000, or secured debts, which are things like your car, or your home mortgage, your vehicle lease or mortgage, other secured debt, like if you go into Best Buy and buy your big screen TV over time. Likelihood is that Best Buy has held back what's known as a purchase money security interest in the TV. So if those secured items go over $1,080,000, in either of those 2 situations, unsecured or secured debts are over those limits, then you will end up into a Chapter 11 case. And it gets a little more complicated and a little more expensive, but that's all I'll mention about it tonight. The 13 is this payment plan where you pay out over 3 to 5 years, and that generally has to do with how much money you can pay over that period of time. You have to have regular income, so oftentimes, even though there's just one of you working, then you can get that approval for Chapter 13. You have to have disposable income, and this is where people often fail because you have to have, you must be in the black instead of in the red. If you have less money, if you have a negative balance each month at the end, you're not going to be able to qualify for a Chapter 13. And so those are the major requirements for a 13. Now in the 7, that's your liquidation. And what you do there, you have someone called a trustee who's appointed both in the 7 and the 13 situation. And what he does or she does in the 7 is they are looking for all of your unprotected assets so that they can marshal those, sell them off, and pay some money back to the creditors that you have. So, and what do I mean by unprotected assets? I talk about exemptions. And let's see, am I jumping over here?
No, it's called, I can't run this thing very well.
Well, let's see if we can. Oops, now I've done it. Oh, you guys.
I pulled it too hard and.
So, in reference to how you qualify for a Chapter 7, there are new requirements, and they're very restrictive in terms of assuming that you've abused the bankruptcy process. And that's if you earn too much money and you're trying to file Chapter 7. If you look at your forms, the first one I have there is a flow chart, which will probably make everybody gird their loins a little bit when you first look at it. But it's the easiest way that I've found to be able to explain bankruptcy. And everybody has to understand, the first question you have to ask is, how much money do you owe, and what is it? How do you classify it? And over 50% of your debt has to be consumer debt. And so, what's consumer debt? It's easier to define consumer debt by what's not consumer debt. Business debt and taxes are the two things that aren't consumer debt. If you have primarily those, and oftentimes some people do, they come in and say, oh, the IRS is after me for a whole bunch of money, and it's more than your credit card debt. You're looking at then being able to file Chapter 7 very easily. Now, arguing with the IRS about discharging all of that debt's a whole nother process. And that's why you may have heard, rumor from friends at the coffee shop or something, oh yeah, you can get rid of certain IRS debt, but it's a very narrow window of things, and you need to go to an attorney like Beverly or myself who have dealt with these kinds of issues in the past. So let's see, am I to you yet?
Yeah, I think.
So, but then what you do is you then ask, what is my gross income? Because you then have to compare and everyone always comes in, does it have to be your gross income? Because the changes in the law were not based on reality, understand. There are things that pop up that's called phantom income. And because in the old days, before these changes in 2005, we'd take a snapshot of your income on the day you file and go, there's your income. Well, not anymore. What they do is they take a look back of 6 months and go, and so for many people, okay, your income's been pretty steady. But for those people who lost their job 3 months ago and have been jobless for the last 3 months, the law requires them to pull in those 3 months way back when and calculate your income with that included. And then you go, wait a minute though, that's not my reality today. No, but it's the credit industry's reality of you. So, right, and it creates phantom income, and bankruptcy judges go crazy over it, but we're all caught within these strictures. So you have to compare your gross income to this median income that the U.S. Trustee's Office and the IRS has come up for everyone in Nevada. And if you fall below that number, then you can qualify for a Chapter 7. So now, looking at exemptions, and lots of people go to bankruptcy preparers, paralegals, typing services. Number one, understand that the only person who can give you legal advice is an attorney, not a paralegal, not someone sitting at Bob's typing service, we do bankruptcies and quickie divorces. They can't give you legal advice. And if they do, you have to question it. Because these exemptions, you can go in, you can Google Nevada state exemptions and you can pull up the list of them, but understanding whether they apply to you in a bankruptcy context is another thing. We have state laws that, and state domicile that affect whether or not it applies to you, because you could have moved here from, Nebraska 3 months ago. Well, then what do you consider your domicile? Is it still Nebraska? So it's very complex, and it differs. So you have to look at that first, and then we can look at what in fact applies. Now in Nevada, it's one of the two most lenient in terms of exemptions across the country. In other words, it has the best exemptions for protecting you, particularly in bankruptcy. For instance, we have for one vehicle you can claim $15,000. And then you're saying, well, but I've got two vehicles. then you have to look at the reality of the situation. Possibly one vehicle is paid off, one you still have you're paying off either a lease or a mortgage or purchase money. And so is the trustee in bankruptcy going to try to sell the one you're paying off? Most likely not. So we're going to be looking at protecting that car that's been paid off with this $15,000 exemption. Now, the other thing you have to understand is there's a potential that if you're a husband and wife filing, you get a bonus by each being able to claim the exemption. So the possibility is on one vehicle, you could claim up to $30,000 of an exemption. So and then I have this other example here. Joint debtors having $30,000 worth of clothing, household goods, and electronics. Are they exempt? Well, you have to learn how to stack exemptions as well, because for household goods and furnishings, and the list of exemptions are in your forms. I'm not going to be going through them one by one, but just for purposes of this example, up to $12,000 for that particular exemption. If it's a husband and wife, they get to double up on that. So you have about $24,000 of exemption. But then you're saying, oh, I'm falling $6,000 short. But we're talking about clothing and other electronics. So you then add on another exemption that's $5,000, and you double that up and you get another $10,000. So you have a possibility of $34,000, which would then protect all of those items. Because people come to me and say, well, are they going to take my big screen TV off the wall? Most likely not. I have had one recently that they did take some of the paintings, but that was a rare circumstance. And that's the other thing. You have to be completely honest with your attorney up front as to what you have. If you've got those sketches by this artist called Monet, the idea won't be, let's just not tell the attorney about those. Because if he finds out, then he or she has a responsibility to tell the trustee and amend your schedules. And the problem that you as the debtor have is that you can be prosecuted for bankruptcy fraud. And you don't want to do that. You don't want to be, the whole idea is to get through this and get a fresh start and not have more trouble. So you got to be completely honest with what you do have in terms of assets. Did you figure out how to?
Sort of.
Sort of. Let's see, so
That's me.
that's you. So I'm going to turn it over to Beverly to do the discharge.
Okay, so how does it end? Hopefully you have a happy ending, and the happy ending is the discharge. And what the discharge means is that if you're in a Chapter 7, for most of your debts, for dischargeable debts, they're gone. Nobody's coming after you anymore for the medical bill, the bill to repair the air conditioner, things like that. In a Chapter 13, the discharge means that if you've made all your payments according to the plan that you've put forward to the court, all of those debts that you paid, even if you only paid half of that medical bill, that whole medical bill's gone. And you get a discharge. And nobody can call you up afterwards and say, where's the rest of my bill? Dude, I got a discharge. And you get a nice piece of paper from the court that says discharge on it. And what I always told my clients was, you want to keep that piece of paper in a very, 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 very safe place. Because if any of those creditors come to you and say, where's my money? You can say, here's my discharge.
And if I can jump in for a moment.
Sure.
There's one creditor today that's jumping on that bandwagon after the discharge more than anybody else, and that's your HOA. And they're trying to claim that all of their debts, all of their fees are not discharged, which isn't the case. Only those after the bankruptcy filing you'll be responsible for. All those before, they're wiped out. Thanks.
No problem. Now, what happens, what's the not so happy ending? The not so happy ending is either a dismissal of the case or a revocation of the discharge. Now, you just heard Kent talk about the Monet or the Monets that you hid in the garage. That's bankruptcy fraud. That can lead to a dismissal of the case. A dismissal means it's like the case was never, ever even filed. All your creditors can come back after you. And if you've committed bankruptcy fraud, it's also kind of a criminal act. If they find out after the fact, you've gotten your discharge, and they say, oh, we just found out about those, those paintings you hid in the garage. And you say, but see, here's my discharge. Too bad. You committed fraud. Give us that discharge back. We are going to revoke that discharge. Not good. Not good. And then again, you get the possible criminal charge. Why do you, aside from hiding the Monets in the garage, why do you get a dismissal or a revocation? Well, you didn't cooperate. One of the things that happens in the course of a bankruptcy is about 6 weeks after you file the bankruptcy, you sit down with the trustee. And the trustee says, I want your last 2 years' tax returns. I'll get them to you. And 6 months later, the trustee's going, where's tax return? Well, you didn't cooperate with the trustee. So the trustee can say, don't give him a discharge. Or the one that every client goes crazy over, sometimes you have to turn over your tax refund to the trustee. If you don't turn over the tax refund, that can lead to a dismissal or a revocation.
And just so you understand, there is an exemption that's called the wild card exemption. It's $1,000, or in the case of a jointly filed bankruptcy, it's $2,000. And most people usually apply that one to try to save part of the tax refund.
So, and you just heard about hiding property or fraudulently transferring property means you tell your brother-in-law, here's the Monets, you hide them until my bankruptcy's done. Okay? Now, there's certain debts that don't get wiped out no matter what. Child support, spousal support, student loans. If you've had something like a DUI and you've hurt somebody, the damages that aren't covered by insurance don't get wiped out. You got to pay a parking ticket or you got to pay a fine based on that DUI. That doesn't get wiped out. You get really ticked at somebody and you go after them with a machete. It's an intentional act. That doesn't get wiped out. So most of your debts that are ordinary get wiped out. But if you've done something bad, where the courts in general think you need to be punished or think you need to pay money for that, that doesn't get wiped out. And you don't get to not support your family. Go ahead.
Oh, but for instance, I'll often have people come to me and say, well, I've got an attorney's fee bill based on my divorce, and do I need to pay all of that? Well, probably not. The attorney's fees that are attributable to support issues, yes. If they are attributable to issues with division of property, you can wipe those out. So that's why I say, go see an attorney, because you could end up getting tripped up very easily and having to pay money back or not discharging something that should be discharged. Okay. Let's see.
Whoops. Did I?
Yeah, that was good.
Yeah, there
So, part of this is yours and part of
you've got the bottom part.
Okay.
So the next question that the clients usually come in and ask and say, what about my car? Do I keep my car? Can I keep my house? You know, if you manage to keep your house in this day and age, you've got more power to you. And we've labeled the first item here as reaffirmation of secured debt. Secured debt is debt that has property attached to it that somebody can come back and claim. The car, the house, the big screen TV, jewelry. A lot of those have, when you have a credit card bill, a lot of those have purchase money security interest, and technically they can be brought back. The property can be repossessed.
And preparing for this, Beverly and I were talking about the case of Sears, where technically they can take the shirt off your back. And I used to do a lot of creditor work and represent Sears, and that issue came up in court one day, but we didn't do it, though.
I have represented Sears as well, and I had been asked to get a used comforter, carpeting that had been installed, the garage door opener that was left in the house in New Jersey. Some kind of things that you kind of looked at the client and you want me to get what? But those, technically, they're entitled to be repossessed. Sears had a purchase money security interest in it. So you can go into the court with the agreement of the creditor and sign and have approved by the court something called a reaffirmation agreement that says, basically, Judge, the creditor and I agree we're going to treat this debt as if there was no bankruptcy. You don't have to. If you're current on your car payment and you go through your bankruptcy and you can keep making your car payments, more power to you. You don't have to do one of these. And there are certain judges in Southern Nevada that will not agree to these agreements.
And what they do is, because you have to go through a hearing to get it approved, and the debtor stands before the judge, and the judge asks various questions about, and you fill out a special form that the judge is reading from, and sees that, well, oh, you only have, if you have to pay this car, you only have $35 at the end of the month, disposable income. I know Judge Regal will not approve the reaffirmation agreement and say, you've done everything required of you by the code. I am not approving this. So keep making your payments, and as long as you make your payments, you'll keep the car. The big issue with why do you need this agreement is if you don't sign the agreement, not only can the creditor repossess the property, but they can also go after you for the deficiency that you owe between the value of the property after they sell it at auction and what you owed on it. So that's.
And if you all, as you all know, the minute you drive the car off the lot, the value goes through the floor, and your debt is still bigger than what the car is worth. So you're going to have that deficiency. Relief from the automatic stay is something that a creditor has to do if they want to repossess your property while you are still in bankruptcy, or sometimes even afterwards, because there's another kind of stay that applies after the discharge. But they have to come into the court and say, Judge, this person is 6 months behind on their car payment. We want to take the car back. Here's what we think the car is worth. Here's what the debt is. Here's why it's not essential to the person's reorganization if they're in a 13, or it's simply just something that it's not necessary to rehabilitation. Give us the car back. And the debtor has an opportunity to say, but, I have $1,000 here that covers my 6 months back payment. Can I make up my back payments and keep the car? And sometimes the judge will say yes, sometimes the judge will say no. It depends what the history is. But this relief from stay is a step that has to be taken before they can foreclose on the car, before they can foreclose on the house, before they can evict somebody from rented property, if you're living in an apartment or if you're living in a rented house, before they can reclaim the big screen, the jewelry, whatever. Loan mods. This is your area. I don't represent any lenders.
Loan modifications, you've probably all heard about them. And you've probably all heard the horror stories of having to resubmit your paperwork 3 and 4 times. Frankly, people have come to me and said, can you help me do this? And there are attorneys out there that will take your money and help you get a loan modification. My feeling is you can fill out the paperwork without my help. You can do all of this and make the phone calls just like an attorney can. I found very few situations where the loan modification can't be done without an attorney. Well, it can be done without an attorney. So before someone says, oh yeah, go to John Smith or something for his loan modification service, be very careful. And what happens is they're going to be looking at, it's almost like a loan approval process all over again. And once you get the documentation all submitted and you get it approved, some of my clients who I've actually helped because they did have problems, the numbers don't match up with what the agreement you thought was there. The statements come and the numbers are different, and you go through having to wrestle with them to make sure the numbers are correct. Because you've got these big companies that the left hand doesn't know what the right hand's doing, and you call one phone number one week, and all of a sudden it's not working anymore, and there's a new number or there's a new voice, and nobody knows where the notes are, and the system is broken. They have not figured out how to fix it yet. And the loan modification, I think, at least in my experience, has been a PR thing for the lending institutions. But it's now coming, now that they're starting, and some lenders are starting to do loan or the balance reductions, which is what they should have been doing from the beginning, bringing your balance in line with what the value of the property is. With that new action in the mix, it does make it more realistic. And then once you file bankruptcy, you can still do the loan modification. Generally what happens is you have to file a motion for its approval with the bankruptcy court, but they're generally approved right away. So if you need to do it, the process is becoming simpler, and it's just, I don't think you need to be spending $800 with an attorney to do it. And as I say to my clients, and I kind of take this more as an initial consultation type of situation, I say, I'd love to take your money, but why not do it when you really need my help, and you can do these loan modifications on your own primarily. So.
Okay. All right, well, thank you both. We've gone a little long, but I'd like to get to at least two relatively short questions. First, to what extent is a primary residence that has been homesteaded protected when the person declares bankruptcy?
Depends. If you look,
It's a lawyer answer, but it's the truth.
If you look in the exemption statutes, and they're not all listed in NRS 21.090, in Nevada you have a $500,000 homestead exemption. However, if you've only lived in the house for 2.5 years, it could be less. They cap it at $125,000. So you have to look at how long you've been in the house, how long you've owned it. So, and most people, if you have $500,000 of equity in your house, be thankful. But most people fall within this $125,000 cap, so it doesn't often come into play. But the answer depends on timing of how long you've owned the house.
Okay, and then one more. How much cash can you have in the bank for a Chapter 7?
Well, good question, because what happens is the trustee looks at the balance in your bank account on the day you file. So most attorneys try to work with clients to get, make sure that the rent or the mortgage is paid, the utilities are paid, everything is paid, and cleared the account. Because you can write the checks, but if the money is still showing there on the day, because every statement shows that daily balance, then the trustee is going to be saying, hey, I want that. But there are exemptions that can protect that. One, you have this wild card exemption, and two, you have an exemption for wages, which can protect up to 75% of your wages. And if that's the only thing that goes into that account, the likelihood is you can protect everything. But once again, I say those exemptions are all important.
And again, it may predict. But as we talked about, the things that cooperating with a trustee, not turning over that bank statement is one of those things that the trustee will want, and if they don't get, it's not cooperation.
All right, well, please join me in thanking Beverly and Kent in a wonderful presentation on behalf of the People's Law School, a certificate of appreciation for both of you. We can
Thank you.
now take our 5-6 minute break. If you could be back here at 20 after, that would be great.
Thank you.
Thanks. You're good.
This is what, your fifth or sixth?
That happens. It happens. Where's the guy to take us apart?
Hello, I'm Larry Springberg, your host for the People's Law School. I'm also a lawyer specializing in accident and medical malpractice cases. The presentation you're watching is one of a multi-session series on the legal topics which affect the daily lives of Nevadans like you. As a member of our home viewing audience, you too can earn a diploma from the People's Law School and receive the course handbook free of charge. To receive a diploma and handbook, simply send us your name, address, and telephone number stating which sessions you have watched, and the information will be mailed to you. Mail your request to the People's Law School, 406 North Nevada Street, Carson City, Nevada, 89703, or call 775-885-7174. The supply of printed course material is limited, so don't delay. We welcome your feedback. The People's Law School is for you, the citizens of Nevada. So let us hear from you. All right, our third and final session this evening is going to be the straight talk on short sales on foreclosures. We're going to have two presenters. First, Jamie Cogburn. He earned a Bachelor's of Science degree from the University of Nevada and graduated cum laude from Thomas Jefferson School of Law. He is an active member of the Nevada Bar Association and the Clark County Bar Association. His areas of practice include business litigation, real estate, contract litigation, and personal injury. Also, we're going to welcome back Assemblyman Marcus Conklin, and so please help me in welcoming Mr. Cogburn and Assemblyman Conklin. Thank you.
Wow, that was quick. I'll try to stay on target on the time on this second one. What I'm going to try to do is I'm going to try to give you a sense of what the legislature has attempted to accomplish over the last 6 years as we've sort of traveled through what most people would classify as a true crisis in the housing market in many ways. I want you to keep the following things in mind. A lot of the legislation I'm going to talk about, I sponsored either as chair of Commerce and Labor or as an individual legislator. And from my perspective, there are three primary areas that I was concerned with. The first is transparency. How do we make sure that what people are doing or are about to do is readily apparent, that all the information is disclosed to you, whether it's by your lender, by your agent, by whomever you're dealing with in the mortgage lending process, in the banking process, or in the foreclosure or short sale process. The second thing is, how do we minimize the amount of fraud that takes place? Early in 2007, it became very apparent to me as a legislator and some of my colleagues that we managed to be in the top 5 in the country on nearly every FBI list related to the amount of fraud that takes place in our community. That's a problem, particularly when you're talking about the single largest asset that most people will own in their lifetime, their home. And then finally, how do we make the process fair to everyone involved? Sometimes it may appear that one person has a greater upper hand than the other. Markets don't always equilibrate the way we would expect them to do so, and therefore it's our job to make sure that there's fairness and balance in any transaction. And so those are kind of my guiding principles as a lawmaker when I evaluate these pieces of legislation. So I'm going to skip through a couple of these because I want to make sure we get time. The first piece of legislation that really was landmark, in my opinion, came in 2007. I worked in 2006 and in the interim with many banks and mortgage lenders and other interested parties, the Justice Association, one of them, for ways to curb foreclosure, fraudulent mortgage practices and unfair mortgage practices in the state of Nevada. There are a couple of key provisions here. One is, this is the first time we've introduced into law that it is a C-class felony to commit mortgage lending fraud. And if you are someone who is committing a pattern of fraud, That's usually multiple cases. In other words, you are truly attempting to game the system, which largely results in somebody losing their home. Then that is boosted to a B-class felony. The other thing that this did was that this bill, AB 440 did, was it made it an unfair lending practice to knowingly make a low, a no, or stated doc loan without determining the ability to pay. One of the things that was happening in the marketplace was banks were making loans. You could simply walk in and say, oh yeah, I make $250,000 a year. How much? $250,000 a year. How much can you loan me? And the bank would say, no problem. We trust you. Here's your loan. Well, think about it, right? You could potentially have a lot of folks on both sides who may be gaming the system. And so this bill truly attempted, if you were going to make a low doc loan, the bank still had an obligation to make sure somehow that you had the ability to repay that loan or not make that loan. About a year later, the Federal Reserve Bank, which governs all national lending institutions, came out with a regulation that mirrored much of the language that appeared in 440 a year earlier. So this was kind of our first foray into the arena. If I fast forward for a moment and kind of play in your mind the historical events here, the housing market began to collapse in early 2007. That's when we see the housing prices level off, foreclosures will start to spike. And by the fall or early winter of 2007, the entire nation is in basically what amounts to a recession, driven by, in most cases, the housing market. People's personal incomes are in decline, their asset values are in decline, okay? By the time the legislature convenes in 2009, remember it's 2 years later, we have a whole host of other issues to deal with relative to foreclosures and lending fraud. AB 440 was part of an effort that I led in the interim of 08-09, or prior to the 09 session, to tackle some of these issues. Some of the things that were a problem. People were being foreclosed upon and they didn't even notice. They didn't even note it. So we had the court send somebody out to post in a conspicuous place that this house was now in the foreclosure process. We dealt with renters. Sometimes a home was purchased on, say, this no-doc loan process for which somebody didn't have the assets to actually purchase the home or the income to deal with it. They were leveraging themselves based on renters and then still couldn't keep up with the loan. And so the home would go into foreclosure with a renter in the home. So imagine yourself, you're a renter, you have a family, you think your home is secure, and then the next thing you know, this home is lost, you're kicked to the curb, and the person who's actually you're renting it from is nowhere to be found for that first month's rent or that last month's rent or that deposit that you made. So AB 140 really attempted to deal with some of these issues that, quite frankly, we couldn't have anticipated in our wildest dreams that we would have been dealing with. Other things that it dealt with, maintenance and control of the property once it's taken over by the bank. Something that typically happens in a foreclosure marketplace is that there's blight upon the community. If you have 15 homes in a cul-de-sac and 5 of them go into foreclosure and then they empty out so there's nobody in it while it's in the foreclosure process and the bank shuts off the water and the bank shuts off the electricity, etc., what happens to the grass in the yard? What happens to the trees in the yard? What happens to the just general maintenance and look of the house? Well, it starts to decline, right? And when it declines, what happens to the other 10 houses in the neighborhood? The value of those houses decline, right? And as those house values decline, what happens to the owner investor that lives in those homes? They turn upside down as well. So 140 was really an attempt to begin to deal with this. We offered cities and counties some authority to go after people who weren't applying appropriate maintenance in their neighborhoods to help support housing values in spite of the fact that we were having a large number of foreclosures. We provided an extension of eviction notice on homes that were going through foreclosure and either had a tenant or a renter, and required that landlords disclose in writing when property be rented is the subject of a foreclosure proceeding. Any violation of this became a deceptive trade practice. So again, this is another piece of truly landmark legislation. Another thing that happened in 2009 is we begin to see the cropping up of an industry known as foreclosure consultants and loan modification specialists. Now, This was a tricky area because you have a lot of people who would like to stay in their home. It's still early enough in the foreclosure process. This is '09. Here we are 2.5 years later. People are looking for ways to keep their largest asset, and they're eager to find solutions. They're not getting responses from the bank when they call, at least in their mind, and so they turn to somebody who either has an advertisement on television or an advertisement in the paper saying, let us help you. If you give me $2,500, we'll secure a loan modification for you and help you stay in your home by finding a payment that will work. Unfortunately for us, I go back to that statistic in 2007 where we were ranked 5th nationally for mortgage lending fraud in the country. This became a hotbed for fraudulent activity as people would collect their fees, $2,500 up front, and never actually modify a loan or be unsuccessful. The actual person who lived in the home, who owned the home, or at least attempted to stay in their home, really didn't have any rights in these types of transactions. So it became a boon for some people to make money, but then walk away and consumers get no help. And so AB 152 set out to tackle this issue. It required a written contract with the homeowner before services were provided, and it required that funds received in compensation be deposited into what amounted was like an escrow account or a trust account. You could collect the money up front, but you couldn't keep the money. It had to be secured as you provided what was contracted before you collected the money out of the trust account. Violations of these rules would be deemed mortgage lending fraud under the statute created in AB 440 2 years earlier. Another thing that happened in 2009 was the advent of deficiency judgments in Nevada, or at least a law that attempted to tackle deficiency judgments. For those who don't know what a deficiency judgment is, if you purchase a house for, say, $100,000, and the house at the time of purchase was worth $100,000, and the value of the house goes down to $80,000, and the house gets foreclosed on. Remember, your loan's $100,000, but the value of the house is only $80,000. You now have a deficiency. And under Nevada law, prior to 2009, the bank could actually take your property, but your property is only worth $80,000 now, and sue you for the additional $20,000. Okay, that's known as a deficiency judgment. AB 471 of the 2009 legislation sought to make deficiency judgments not legal, or not allow deficiency judgments would be the appropriate legal terminology, I think, for homes that are known as purchased money mortgages. So if you are a homeowner and this is what a purchased money mortgage is in layman's terms. If you're a homeowner and you go buy a home and you don't take out a second on your home and you live in your home, then the value of that loan and the value of the home are always going to be even. Okay? So, but that was for all loans going forward. It's a little bit late. But nonetheless, it's something we learned through the process. Now, if you choose to use your home as an investment, then you can still be rendered a deficiency judgment against you. But so long as it's the purchase money mortgage, the first loan made, you never adjust it. Those two will always be equal in terms of value, not necessarily on paper, but in the eyes of the court, should you ever default or the home go into foreclosure. So that's what AB 471 did. And you can imagine how that might have benefited a lot of people had it been something we had done as a state many years earlier. But hindsight's kind of 20/20. It also limits, from an economist point of view, it also limits the amount of money that might be available as banks assign a different risk factor to the purchase of homes. What it also does is other states that have this potentially could have a more balanced market because money isn't so free-flowing either. A bank knows that they have to make the right loan up front because if they don't, they're going to lose the money if it goes into default. So you can see how it's starting to balance out the transactions that are taking place. I'm going to fast forward to 2011. There are two bills that happened in 2011 that have been the subject of a lot of discussion, a lot of press, and as I think you'll probably hear about later, some court proceedings as well. The first one is AB 273. AB 273 does several things. The first thing it does is it extends AB 471 to borrowers who take out piggyback loans but are still as part of their purchased money mortgage. So 471 was the deficiency judgment bill I just spoke of. And a piggyback loan, I guess another way of quantifying it is it's a jumbo package when you purchase a house. So some people will purchase a house and instead of getting one loan, they'll take out two at the same time. They'll take out $100,000 plus 20. And so they borrowed $120,000, which was the value of the house. But they couldn't get the full amount, so they had to take out a second loan at purchase. If it is part of the original package to purchase that house, both loans would be covered under the deficiency law, okay, or lack thereof. It also prevents creditors from receiving judgments in excess of what they paid for the right to pursue those judgments. It prevents lenders from receiving double payments for a loss that is covered by insurance. It requires a junior lender to commence an action money judgment within 6 months, as senior lenders much do. And I think there's some additional information. If you look on the bill, in the back of the bill, there's a bunch of effective dates for each provision. They don't all go into effect at the same time. It's kind of layered in. Now, let me tell you what some of these things are and why they're important. And this wouldn't be the only set of circumstances, but let me use it as just an example of the types of things we might be talking about. If you owe the bank $100,000 on a piece of property that's only worth $80,000, you might want to negotiate the bank to get a reduction in your loan amount down to $80,000 and then continue to make payments. But the bank may have ulterior motives. The bank may want to sell your loan to a creditor for pennies on the dollar, let's say for $60,000, and let the credit company, the collection agency that they sell it to, come after you for the full $100,000 plus penalties. Okay? Instead of dealing with you as the homeowner, where the bank might have had a certain amount. You say, well, why would a bank do that? Well, one of the reasons a bank might do that is your $100,000 loan might have mortgage insurance attached to it. And the mortgage insurance is going to pay 80% of any loss. So if the bank sells it for $60,000 and they collect 80% of the $40,000, right, which is $32,000, the bank has now collected $92,000 of their $100,000, and all they would have gotten from you by negotiating it down was the $80,000. Okay, so you can see there's a lot of potential incentives out there as to why banks may or may not be cooperating, why they may choose other avenues. Now, it doesn't make the banks wrong, it just makes the way the laws are written and the types of transactions not necessarily conducive to the consumer or necessarily in the best interest of the consumer, or at least put them on the level playing field with the banks in terms of being able to negotiate. Other things that we were concerned with here, prevents a lender from receiving double payment for a loss. There wasn't a place in statute that I could find that said that a bank couldn't collect on insurance and file a deficiency judgment. So this bill sought to correct that and make it very clear that if the loan was for $100,000, the most the bank could collect was $100,000. So if you got 80 from that consumer and you could collect only 20 on other things, if you got 80% of that 20, which is $16,000 from an insurance company because the consumer was paying for mortgage insurance, then the most deficiency you could possibly get would be $4,000, which would be all the money that was left, right, to get up to the $100,000. So lots of things we're trying to clarify here. Those are only some examples. I think in terms of the actual law itself, it's far more broad-reaching than that, but you can see how it might affect the average consumer. The other bill that takes place in 2011 is AB 284. This is a bill that I sponsored and worked very closely in the interim with the Attorney General, Catherine Cortez Masto, on. Many of you may have seen in the news what is known as a robo-signing controversy. This is where banks will sign documents wholesale, sometimes with a notary, sometimes without a notary, where documents may be recreated instead of the original documents. This has created quite the controversy. As you can imagine, this is the largest asset that you will likely own in your lifetime, or the largest type of asset you will own in your lifetime. You sign a contract to make payment on it, and the bank doesn't need to require that contract in order to foreclose on your house. They can simply use their word. And so this bill attempts to bring it back to parity, that if you're going to attempt to foreclose on somebody, you need to be able to produce the documents that say you have legal right to do so. I think that seems quite fair. It also requires that if you're going to foreclose and file a notice of default, which is usually the first step in the foreclosure process, that you must include a notarized affidavit of the trustee's authority to exercise that power of sale, because that's how a foreclosure process ends in a foreclosure sale. Failure to do so would be perjury. It adds additional civil penalties for mortgage lending fraud. It authorizes a private right of action when the homeowner's rights are violated, and it increases penalties for the crime of false representation of title. In some respects, we were the Wild West of home ownership. Money was easy, money was quick, it was simple. People made a lot of advances for themselves, but at the same time, it allowed for a lot of opportunity for hanky-panky. It's not far-fetched that I could have knocked on any one of your doors at any time and said, hey, I now own your house, I bought it from the bank, and I need you to vacate. And you might have actually believed me, and quite frankly, under the law, I might have actually been able to get away with it. And you know what? You could have done it to your neighbor as well. So these laws really needed to be strengthened. They needed to be tightened. So if at the end of the day, everyone understands that when they do get title, that title is clean and they truly are the owner of their home. So I will stop there. I know that was a little whirlwind. I know I skipped a few things, but they're in your packet, and I'll turn it over to Jamie.
And before I get started, I want to, everybody should understand how hard it is for Assemblyman Conklin up at the legislature. When you're up there and you're arguing for these bills, you're arguing for the people. And without a doubt, these bills have affected the way the banks do business and the way they treat homeowners and the way they actually treat consumers. Unfortunately, it is very hard sometimes for a consumer to fight back against the big bad bank. Even though you may be in the right, sometimes it's not what you know, it's what you can prove in the court of law. And sometimes, unfortunately, the money determines what's going to happen. If you can't afford an attorney, if you can't move forward and litigate your case, you're lost. And these laws have really tried to make it a level playing field. And without a doubt, no matter what your political, views are, you've done a fantastic job for every consumer in the state and every homeowner in the state, and you should be applauded for that.
Thank you.
And I'm going to breeze through some of this stuff also, because I know we're running short on time. What I can tell anybody is, no matter what you do and what decision you try to make when it involves your home, educate yourself. Whether you decide to go, there's many legal aid places out there, there's many Hope for Homeowners, there's many places that offer free advice. Our office offers free consultations, but there's places out there that you can go educate yourself. And some of it's the internet, some of it's websites, some of it's friends, but we all hear a lot of myths, we all hear, great stories, bad stories, and we don't know what to believe. But whatever you do, you got to educate yourself to make a decision. And I'm just going to run through quickly. We all went from boom to bust. Essentially, if you look here, you have back in '93, this red line is if we had a normal 3% growth, which is the normal average growth. You see here, 01, it starts going up. We have a huge spike that we all remember and we're fond of. And then we now have the huge drop here. And that's where we sit today. We've all read the articles. We see it all the time. Las Vegas is the #1 place for underwater homes, meaning you owe more on your home than your house is actually worth. In Las Vegas alone, we're #1 again in the country, which this is something we don't want to be #1 for, but over 70% of all homeowners are underwater. And we call this the lost decade. Some people will call it the lost 2 decades. If you look, home prices, the average home price in 2011, at the end of 2011, is actually less than it was in 1999. And those are the things that we're fighting against right now. This is a really scary slide. This is, the red are people that have negative equity, that are upside down. The green are people that have positive equity. The gray are bank owned. And I can tell you that has increased over time, because this slide's about 6 months old. You need to know your options. And your options are really simple. You can do a loan modification, and I'm going to go over all of these in some little bit of detail. You can short sell your house. You can do what's called a deed in lieu. You could file a bankruptcy. You could let your home foreclose. The other thing that you can do now that I did not put in here is HARP. There's a program called HARP, which is a refinance program. And if you have a Fannie Mae or Freddie Mac loan, which is about 50% of all homes in Nevada, you can do a refinance to today's rates. They will not lower your principal, but they will lower your rate. So if you're at 6.5, you can go, rates are right about 4 right now. So you can go to 4%. The other options you have is to do nothing, which is probably not the best option for anybody. Loan modifications have sucked, just to put it frankly, for years. And we do them at our office, and with about 95% accuracy, you could walk in and I could tell you, you will not qualify or you will qualify. And you may qualify, but it will take us 6 months, and it's like banging our head against the wall to try to get it done for you. They are much better now, I will tell you that. They're actually starting to do the thing that probably Assemblyman Conklin would say as an economist, they need to reduce principal. Not necessarily to market value, but at least make it where you don't feel like you're at the bottom of the Grand Canyon trying to hike out with only a little cup of water. If you're only 15 grand underwater, if you're 10% underwater, that is something reasonable we can all deal with. And we can start investing back in the economy and start doing home improvements, start doing the things that we want to do that we don't do right now because we go, I don't know what I'm going to do with my house. Do I want to add a patio? If I'm going to move in a year? Who wants to spend money if you don't know what you're going to do? It is still a headache. I'm not going to lie about that. There's recently the $25 billion settlement we've all heard of that our state was involved in, and it is actually helping people. I will tell you this, I didn't believe it was going to. I've already seen drastic measures and results that have happened from it. So I have to say I was a naysayer, but I'm coming around, and the banks are starting to come around, which is important. A short sale. A short sale is, just so everybody knows, is selling your home for less than what you owe. What's important is if you're going to sell your home for less than what you owe, if you owe $200,000 and you sell it for $100,000, well, we see, it doesn't take a genius to see that there's $100,000 out there the bank is losing. And I could go on for hours about do they have insurance and things like that, but we won't. But if you're going to short sale, the one question we always get is who can short sell? And to about 95% to a T, anybody can short sell. It is how you present it to the bank in certain things like that. So most people that come to us say, oh, well, I can afford my payment, but I'm making a business decision. And I read a great article in the New Yorker just recently, and it was about American Airlines. They filed for bankruptcy. And all the economists and business people said, that is fantastic. That is the greatest move. Stations Casinos filed for bankruptcy. They shredded a lot of debt. That is a fantastic move. But when most of us think bankruptcy, we think, hey, you're losing everything. No, you're restructuring your debt in many circumstances. And companies do it all the time. And a funny story is the Mortgage Bankers Association, which governs it's association for mortgage bankers such as Bank of America, Wells Fargo. They had a commercial building. What'd they do? They didn't think it was a good investment any longer. They did a short sale. So the banks will tell you, hey, we don't want you to short sell, and we want you to pony up all the difference, but the Mortgage Banker Associations is short selling their building. And many businesses are restructuring their debt, and that's what you're doing. You're taking a bad situation and making the best out of it, and that's all you can do. The important thing is if you're going to do a short sale, you must get a deficiency waiver. Although Assemblyman Conklin has got some great laws passed, they are not retroactive. They are going forward, which means you have to take a loan. If you took a loan out today, we are considered a non-recourse state if it's your primary residence. But if you had a loan from 2005, like I have, you will have to get a deficiency waiver. The bank can't come after you. If you have money, if you have other assets, you need to disclose those to the bank, but there's a way to disclose them, and some assets are protected, and you need to know how to do that also. A deed in lieu. A deed in lieu is where you say, bank, I'm going to give you the keys to my house, you take the house, and I'm going to walk away, and you're going to forgive the debt. They are rare. I will just tell you that right now. But partly the reason they're rare is because you can do a short sale, and the bank would rather do a short sale. I promise you from years of experience, they always want to do a short sale. Every once in a while, it's appropriate, but it has to be a unique situation because the bank does not want to take that property, because if they take that property, similar to a foreclosure, they have to then sell that property. They have to maintain that property. They have to pay the HOA dues on the property. They have to do all those things that we do now. Bankruptcy, everybody that was here earlier, that was discussed in detail. And there are circumstances that it's appropriate. And you need to consider those options. Foreclosure. It is rare that I tell someone they should foreclose, but every once in a while it is appropriate. And I'll give you a situation when it is appropriate. If you're negotiating a short sale with your first lender and they say, we will not waive the deficiency, meaning we will not release you from that debt, you are almost better off letting them foreclose because you have more rights and more law on your side than if you move forward with the short sale. And that makes no sense, don't get me wrong, but there's lots of things that make no sense that the banks do. It is rare that that happens, but it does happen, and you really have to be aware of your situation, and that's why I say you have to educate yourself. I'm going to go through some of the stuff you're looking for if you're doing a short sale, and the reason I say short sale is because it's probably the most popular thing that's happening these days. But I do think now that the banks are starting to come around, you're going to see a lot more principal reductions. You will not see principal reductions to market value. You will see big principal reductions to where if your house is worth $100,000, they'll reduce it to 110%. So they would reduce your loan to $110,000. Or they'll reduce your principal by 30%. So if you're only 30% upside down, then yes, you could get to market value. But if you're 50% upside down or more, like many of us are, they're not going to reduce it to market value. And if someone tells you they are, they're lying to you. And Assemblyman Conklin talked about some of the scams out there. We have sued many out of just principle because you're stealing people's money. These people, they were mortgage guys, and nobody was getting mortgages anymore, so they became loan modification guys. And all they did was take money, the same people they gave a bad loan to, they then say, hey, we're going to help you with that loan, and they would steal that money too. You got the good. Up here it says, hey, bank agrees not to pursue a deficiency judgment. Here's the bad. The owner of your mortgage note, the mortgage insurer, they put all this legal mumbo jumbo, reserve the right and retain the right to pursue and collect any deficiency judgment. That is what you do not want. And what you really don't want is the ugly. Of all people to sue, this is a case that we have. This is Fannie Mae. Fannie Mae is suing for a deficiency. And if people don't know, Fannie Mae is now a government entity. It was a quasi-government entity before, whatever that means. It is now your tax dollars. And they're suing for a deficiency. And to give you just a little bit of background on this particular case, these people lost their job. They bought this house for their mother and father, moved them out here, put them in the house. Within a year, their mother died, and then the father has Alzheimer's, and he has to be put in a home. And then one of them loses their job. They can barely afford their own house. And they were paying the bills for their parents. And they're suing them for a deficiency judgment. And unfortunately, they got bad advice, and someone told them, don't worry about it, the banks aren't doing anything, just let it foreclose. And that's basically saying, I'm going to stick my head in the sand and do nothing. This is the good news, if there is any. We are the most undervalued city. Investors are buying up our property like crazy. And what we have to do is, if you're going to get rid of your house, get rid of it, because you need to buy another house, because that's the only way the economy rebounds. We all have to own homes, because then we build the home up, we pay the HOAs, the yard you take better care of the yard, you do more things. You put blinds in. You do different things that put money back in the economy. Right now, if you become a renter, if you're a homeowner and become a renter, more than likely your investor that owns that home is out of state, if not out of the country. These are just more and more statistics saying, hey, this is the best time to buy. This right here was the same slide I showed you earlier. Right here, we are 45% under where we should be if we just had our normal 3% growth. So it's like a pendulum. It goes way up, but it goes way down. And now, we'll open it up to questions. I know that Larry has a lot of question cards, and for myself or Assemblyman Conklin, and we'll take it from there.
Okay. How long does a creditor have to go after a debtor on a second if the property was foreclosed?
That depends. There's that lawyer answer, right? If it foreclosed after July of 2011, July 1st of 2011, it is 6 months because of a new law that was passed and introduced by Assemblyman Conklin. If it foreclosed prior to that, it is 6 years.
6 years.
And there's another important part of the law, and he touched on it briefly. If they sell that to a debt collector, so Bank of America forecloses, they have a big deficiency second for $100,000. They would sell that to a debt collector for $5,000. That debt collector would then come knocking on your door and say, hey, I want that $100,000. They used to be able to do that. They cannot do that any longer, which is essentially the law has wiped out people buying up that debt and trying to make a profit on our misery. So it depends on when the foreclosure happened.
Okay. What effect does foreclosure have on an equity line of credit or a second mortgage?
The same. They're not treated any differently under the law.
How are they treated?
So if it's a second or a first and they foreclose today, they have 6 months to come after you. And I will tell you, the banks are getting quicker. There's 2 banks in particular that are moving very quickly, Citibank and Wells Fargo. Right now, those are probably the quickest moving, but they have the 6 months. Whether it's an equity line, second, third, fourth, fifth mortgage, doesn't matter.
Okay. This question is kind of cryptic, but I think it's for you, Assemblyman Conklin. What are the effects of Senate Bill 414?
I don't know. Somebody's going to have to remind me what 414 is.
Senate Bill 414 was the banks must approve or deny a short sale within 90 days.
Oh, that was Mike Schneider's bill.
Yep.
Yeah.
And I'll go ahead and answer.
Go ahead.
As of right now, there's been very little effect because there is no private cause of action, meaning you as a consumer cannot sue the bank to make them do that. The only person that can do that is the Attorney General, which recently she did just come out and say, hey, we're going to start enforcing that. But the reality is that they are understaffed and overwhelmed with huge amounts of fraud that are going on still to this day. So it's hard without a private cause of action.
Okay. Why are the banks not funding well-qualified HARP applicants?
Let me attempt to answer that.
Yeah. You're an economist.
I'm just gonna, and this is just from experience. The government has attempted to put good programs out there, but the bank operates in a broader environment. So if the HARP program is not attractive to the bank, if the bank can actually make its way to more money out of a bad situation, it's going to do so. It has an economic incentive to do so. It has stockholders that want a return on the bank's effort. And so, my best guess on the HARP is that the bank has other alternatives that are more in its interest. May not necessarily be in your interest, but that just the nature of economics.
And in my opinion, that is correct. In other states where they're not as far underwater, if you live in Denver, Colorado, and the market only dropped 10%, they like HARP refinance there because they're still protected. But when you're talking about refinancing a $400,000 mortgage and the house is worth $180,000, they kind of see that writing on the wall in most instances. Whether it's, if you decide to move 10 years from now, you're still upside down. And that is the sad part about it.
Yeah, there's an additional The additional problem is a good number of loans that have been made are no. I mean, you went and you made your loan with Bank of America, Wells Fargo, City National, whoever you made it to, and then they took 100 of their loans and sliced each loan up 100 ways, packaged it up into a new loan. These are known as derivatives,
Right.
and then sold that on the open investment market for return. So your loan isn't necessarily owned by one person anymore. It's owned by thousands of people, and renegotiating becomes very difficult.
Okay. Are you actually seeing mortgage lenders waiving deficiency judgments in writing these days?
Yes, probably about 90 to 95% of the time. They may ask you to contribute money. They may say, hey, we are going to agree to the short sale, but we want you to share in the loss, is what they call it. And that means you may have to come in with a couple of $1,000s. I'd probably say the average right now is about $1,500.
The rules are changing such for the banks that it's actually a better proposition for them to short sell, which is what we want. Short sales
Right.
are usually made inside the community, within the community. They actually have upward pressure on pricing, which means there's upward pressure on home values. For those of you that are still in your home but you're upside down, what you want to encourage is more private sales to take place, because that actually changes that graph, that's going down. What we're trying to do is turn it back up. So encouraging more short sales is actually beneficial for everybody.
And the banks prefer a short sale over almost anything. They still get their mortgage insurance dollars in most circumstances. And if they were going to foreclose, it costs them a lot more money to foreclose.
Okay. In the case, and I think this is where a deficiency is waived, is the amount of the waiver, is that a taxable event by the federal government?
It is always a taxable event, but if it is your primary residence, there's a tax exemption that's good through the end of the year that may or may not get extended. That is good through the end of the year. So essentially you would pay no taxes on it. If it's an investment property, it gets a little bit more complicated, but there are ways to offset it, because if you bought something for $400,000 and you sell it for $200,000, you get to write your loss off also, because you lost money, even though you may have borrowed all of that money.
Okay. Are there currently any state or federal government programs that can be used to strongly encourage a bank to lower the homeowner's interest rate and thereby monthly payment?
Well, the HARP program does that, but the HARP program that Jamie mentioned earlier does that. It's just that you have to meet certain criteria in order to be eligible. And the problem Nevada has had is those criteria are built off of a national average.
Right.
We are not the national average. We are far below it in terms of this foreclosure crisis. So a fewer percentage of people will actually qualify for that program in Nevada than they would in a state that, say, has an average rate of foreclosure, someplace like, I don't know, Kansas or
Right.
Kentucky.
Des Moines, Iowa.
Your hardest hit states like Arizona, California, and Florida, it's harder for them to take advantage of it.
You can modify. I would probably say the average right now is about 1 in 5 you will get a principal reduction, 1 in 4 maybe. Otherwise, they're always just adjusting your rate. And you can pretty much calculate before you even apply to the bank for a modification, if you know what you're doing, whether you're going to qualify or not. They use a formula. They have guidelines that they put out, and you have to understand the guidelines and use them. But, you could come in, I could look at your finances and go, you'll never qualify. Don't even bother wasting your time.
And now there are the hardest hit funds programs are ramping up now too.
Correct.
And that is a federally funded program. I want to say somewhere in the neighborhood of 180 million.
Right.
Into Nevada, and that will actually help buy down
Your principal.
Your principal, not necessarily all the way.
They do matching, and credit unions are actually taking part. I didn't realize this until about 3 months ago. Credit unions are actually dealing in hardest hit funds also, which is rare when you deal with a credit union that they would participate in any federally program or any government associated program.
To what extent would a short sale affect your credit score?
What affects your credit score actually the most is if you miss payments. If you stayed 100% current and just did a short sale, you're probably looking around 40 points. So if you were a 750 credit score, you probably go to about 710. It's the missed payments that actually hurt the most.
All right, I think we hit the highlights, and we've certainly gone a few minutes over. So I'd like everyone to join me in again thanking Assemblyman Conklin and Jamie Cogburn, and a certificate of appreciation
wow.
from the People's Law School for you.
Oh, thank you.
All right, well, thank you everyone for joining us
Look forward to working with
today.
you sometime.
Next Tuesday, we'll have our second session, again beginning at 6 p.m., and we hope we'll see all of you at that time. Thank you again.